All right. The Court of Appeals and the Court of the Sixth District of the State of Florida is now in session. The Honorable Ellen Craver, Chief Judge, presiding. All persons having business before this court drawing near to attention will be heard. May God save the United States of America, the State of Florida, and the Commonwealth.
All right, good morning, everybody. Welcome to an oral argument session of the Sixth District Court of Appeal. As Deputy Marshal Tidwell said, I am Dan Traver. I'll be presiding today. I'd like to introduce the rest of the panel. Seated to my right is the Honorable Roger Ganim. Seated to my left is the Honorable Brian Lambert. Judge Lambert is an associate judge with our court. Through the kindness of the Supreme Court, he's been assigned to help us out during a time of need, and we're happy to have him. There is one case on our docket this morning. It's case number 23-2615. King Reyes Transport Inc. and Rigoberto Reyes versus Abdullah Baker. In terms of the appellant, we typically have a 5-minute rebuttal, but it can be more or less depending on what you would like to do. What would you like?
5 minutes is fine.
Okay, at your convenience, ma'am.
Good morning.
Oh, I will say this too, and I'm sorry, this should have been part of my spiel. Obviously, we're streaming live on YouTube. Be mindful of that. Anybody who hasn't yet silenced their cell phones, we'd be grateful if they did. Go right ahead.
Good morning. May it please the court, Donna Crosby on behalf of the appellants. With me at the table is Sean McCamey, who was the trial attorney in this case. We've raised several issues in our briefs, and time permitting, I'm going to primarily focus on the Banger issue unless the court has a preference. Time permitting, I will then address the remitter argument. At issue in this case, at the center of the case, is the trial court's order. The order required with regard to expert witness disclosure that the witnesses be disclosed, meaning furnishing in writing the expert's name, the business address, telephone number, CV, medical specialty, statement of the specific subjects which the expert will testify and offer opinions, the party or parties against whom the expert will be called to testify. In addition, in providing the disclosure, the attorneys were required to provide 3 dates of depositions for the experts. I'm not going to go into the facts unless the court has any questions, but I hope
What's
the court has.
importance in your mind of those 3 dates?
Excuse me?
What's the importance in your mind of those 3 dates? Does it have any relevance at all?
Does it have any relevance as far as requiring the parties to provide the dates? Well, sure. It's to allow the parties to be able to depose the witnesses in time for trial and to understand what the substance of their opinions is.
Why weren't they included?
Why were they not included in this case? As we explained to the court, in this case, Mr. McCamey came into the case later. Nothing had been done by the prior attorneys. They had requested, Mr. McCamey requested that the plaintiff provide the vehicle that was involved in the accident. Did a request to produce. 20 days, I think, after the request to produce, the plaintiff sold his vehicle. We came into the court and said, Your Honor, we are trying to locate the vehicle so that the experts can examine the vehicle, analyze the electronic data on the vehicle, and provide an opinion as to causation. These were our 2 causation experts. The plaintiff sold his vehicle. We argued, they argued that they had every right to sell the vehicle. Well, the Supreme Court and League of Women Voters said you don't have a right, even if there's no legal duty. If you are reasonably certain that there's litigation, then you have to maintain the evidence, and that didn't happen. We sent our experts, we tracked the vehicle down in New Jersey. We sent our expert accident reconstructionist up to New Jersey. We explained to the court, we attempted to comply with attempted to comply with the court's order disclosing the substance, what they were going to be opining as to, but they had not yet formed their opinion because we had not located the vehicle.
Counsel, let me ask you, Judge Travers' question, why weren't the dates given or the experts ready when disclosed? I don't think we can relate that specifically to the car being gone because these experts were disclosed on November 28th. And even if we think, time began in this case when the last trial counsel began in August of 2022, why from August of 2022 through November of 2022, was there not enough time to find experts, request the car, and do the work necessary so that when that expert disclosure was made, it complied with the pretrial order that expects dates when the experts not only can be deposed, but we will be ready with their opinions. In other words, disclosing experts who, without dates, in fact, on the face of the disclosure, specifically won't be available for deposition until after the pretrial conference, late January, early February. Why isn't that just a deficient expert disclosure on its face?
Well, I'm not arguing that it was in compliance with the court order. I'm not arguing that. I'm arguing, yes, I don't know the answer to why specific dates weren't given. I may be able to come back on rebuttal and explain that to you, but I know that one of the arguments that counsel made to the trial judge was that as soon as he came into the case, there was a motion for summary judgment that he had to address, and there was a motion for sanctions and things like that. As he was getting up to speed in the case, he also had to stop and address that. I know, at least with regard to the CME physician, that he had several that he had approached about being CME experts, but they weren't available or had conflicts or whatever. But I can't answer the question as far as why specific dates weren't given. I don't know the answer to that.
But I think if I think what Judge Ganem might be getting at, he'll correct me if I'm wrong, but it's not just the failure to provide the dates. It's the fact that you're saying the depositions, if they're going to happen, they're going to happen after the pretrial conference, after the trial period is theoretically started at the beginning of February, and only after the plaintiff's experts have been deposed. I mean, it's not just that it's a deficient expert disclosure, it's that it's almost entirely wanting, I guess.
As far as the deposition dates,
Well, as far as the notion that you're going to say, we're going to wait until the last second, and whether has to do with the car or doesn't have to do with the car, theoretically, a causation expert could testify to something not having to do with the car. In fact, you look at the disclosure itself, there are numerous other topics in which the expert could have been prepared to testify had a deposition date been given. I wonder if it's a different scenario if the disclosure would have said we're ready on all of these things except for this car thing that you're slowing us up on.
look, like I said, I'm not going to tell you that or argue that he complied with the disclosure as far as giving the dates. But we do need to get to the issue of what happens when there is non-compliance. What are the Binger factors? What must the trial court look at to determine before you strike our critical witnesses? There are two only causation witnesses. What sanction are you going to impose before you strike? And what are the considerations?
Let me ask you about the Binger factors. The Supreme Court lays them out, but also says, after looking at these factors and any other relevant factors. So we have not only the three Binger factors, but also this other relevant factors category. How are we, or how should the trial court weigh the different factors? In other words, one of those factors is disruption of efficient, proceeding of this case or other cases. So if granting the cure, which in this case seems like it only could have been a continuance, if granting the cure would disrupt not only this case, but other cases on the court's trial docket, how is it an abuse of discretion for the trial judge to say, in this situation, that factor gets the most weight and therefore I will strike the experts?
Because one of the fundamental rights of a party in a lawsuit is to call witnesses. The courts in Bangor, we don't really need to go further than Bangor, but every case that has interpreted this issue since Bangor has recognized that it is an extreme sanction to strike a party's witness without considering alternative sanctions, without finding prejudice, which all the cases, and even the Bangor court says prejudice, meaning surprise and fact, is the number one consideration.
What would be the alternative sanctions then?
The alternative sanction in this case, unfortunately, would have been a continuance. And
That's not a sanction.
I mean, right, okay, I understand exactly.
That's what-
The alternative remedy.
But you're saying Dinger says you consider alternative sanctions if you're not, if the worst sanction is the striking of witnesses and don't go there, consider alternative sanctions as the trial court. And I'm empathetic as I used to be a trial judge for a long time before I was here in this court, but I mean, here on the appellate bench. And you would sit and you'd get these epistles coming from the DCAs and saying, you should have done something different. And us trial judges say, well, what do you want me to do? So that's what I'm asking you. I finally get to ask that finally after 25 years of being a judge. What do you want to have? What should have the trial judge done? What would be alternative sanctions saying, you violated my court order. We're getting this, Tallahassee is saying we gotta be strict on continuances. We need to run a tight ship now, especially pre and post COVID or during COVID and post COVID. All right. Tell me the sanction.
Oh, that's a good question. Maybe,
I wish somebody had answered that to me when I was a trial judge, but
um,
they never listened to me back then, so.
maybe in this case, some kind of limiting of the experts' testimony, limiting of the opinion based on the plaintiff's argument as far as how he was prejudiced and not being able to come up with another, a rebuttal witness or, something short of striking the witness. I don't know under the circumstances it would have to play out as far as the plaintiff coming in and saying, I'm prejudiced in this way. In this case, one of the arguments was, well, I'm not going to be able to challenge the witness by way of a Daubert motion. Maybe being able to, I
That's
think
a bit
under the,
specious though. I mean, I know Daubert, but I mean, this is not a new type of science or whatever, Fry and then Daubert. The focus was, you don't have Daubert motions when you have a doctor testifying and say, well, we're not sure you qualify under Daubert. So I don't know that a Daubert motion really be applicable here. I know it's an option under the pretrial order, but
right.
biomechanical engineers have been used for decades in this litigation, so it's not a.
And that was another one of the arguments is that plaintiff's counsel said, I'm very aware of what the what an accident reconstructionist is going to talk about. There was no surprise. In fact, they knew from the beginning,
When I look at your arguments, at what point do I have to kind of pull away my independent knowledge of what's going on in the Ninth Circuit in terms of the level, the insane amount of busyness that's going on there? Is there such a thing as a short continuance in the Ninth Circuit these days? Or is the effect of a continuance 18 to 24 month bump down the line?
I don't know. I don't practice here regularly in the Ninth Circuit, but there has to be some balance between pushing these cases through and allowing a fair trial. We're not asking for a perfect trial. We're asking for just a fair trial. And in this case, what happened?
So I guess the answer to my question then would be, you don't know?
I don't know the answer to what,
Let me ask
was
you this
it?
then. What effect, if any, do we give to the fact that your client is the one who noticed this ready for trial 2 years beforehand and said that we're ready to go?
Under the circumstances, I don't think that should be a consideration.
Because those
Because,
words don't matter?
because you don't punish the client. You don't punish the client for the fault of his attorney. And we've argued in this case that, and the trial judge recognized, it's on several occasions, Mr. McCamey, if you had been the attorney from the very beginning, we wouldn't be in this position. But I looked at the court docket and I note that nothing's been done except the plaintiff's deposition had been taken. And she said, ever since you came into this lawsuit, you moved mountains. You have been prepared. You've come to hearings. You've done what you need to do.
Was there a written response to the request to inspect the vehicle from the plaintiff side? Did they respond to it?
I don't recall if there was, I just recall the hearing that took place because I think what happened was they were having difficulty getting hearing dates. And I know that it was kind of combined at the hearing with the motion to continue.
Let me rephrase. Did the other side object to the inspection? Did the plaintiff side object?
Well, I said in the brief that yes, they did. They waited the 30 days and that's another, issue is, yes, they had the right under the rules to wait the time and to respond, but they did. And knowing that, we were under time constraints, every time we tried to move forward, we were roadblocked by, plaintiff's counsel. We can't schedule, we can't get a hearing date, we can't,
So the car was roadblocked?
the car was roadblocked. Right, yeah, I mean, that, all of
Ready
these.
your rebuttal time, if you want to finish.
Well, I saved my rebuttal time unless the court has any more questions. Thank you.
Good morning, judges. Attorney Jeffrey Bird. Represent Mr. Baker both here at the appellate level, but also at the trial level. And as fate would have it, this is the exact courtroom where we picked the jury to try this case a year ago, in this exact courtroom. Accompanied by my trial partner as well, Mr. Keena Graham Williams. I prepared a 4-page outline, but I find that typically these oral arguments go better if I just answer your questions at the outset. Instead of worrying about the outline. So I'm happy to do that if your honors would like to present a question before I begin.
Well, Mr. Bird, I'll take you up on that. Let's focus on the car.
Yes, sir.
There was a pending request to examine the car. I think no one would dispute it's a key piece of evidence in the case. And the car gets sold before the response is due. But the sale of the car and the subsequent efforts required by the defense experts to find the car and examine it, they had a direct effect. Those efforts, that delay had a direct effect on their ability to finish their expert reports. Why isn't the sale of the car in and of itself, create grounds for a continuance? The plaintiff got rid of evidence, and that hindered directly the defense's ability to examine the evidence and prepare expert reports.
That's an excellent question. And I also want to dovetail with the question you asked, Judge Lambert, because you asked if there was a response by the plaintiff. And while you asked that question, I checked the record and I don't see that it was made part of the appellate record. But from my recollection, I believe that there was a response timely filed. So I want to address you, but in answering your question, I think that it's been taken out of context what actually occurred, but Judge Beamer understood all of these issues. Mr. Baker and his family were moving back to the Middle East. The only reason they remained in Central Florida was because of this pending litigation and trial. They were selling all of their assets, not just this car, to avoid an inspection. This Judge Beamer very clearly, and is documented both in the brief and the appellate record, said, if inspecting this car was so important, this car has been around for years. You could have done this much before waiting to the last minute in November of 2022 to inspect it, number one. Number two, when you look at the, I contend, untimely and inadequate expert witness disclosure, there was nothing in there that said, these experts will inspect the vehicle, that they will get the event data recorder material and information from the vehicle. It just wasn't there. So I hope I've answered your question, because it's been portrayed that my client spoliated or did something to impair their ability. There was never a letter, a request that he keep the vehicle, that he maintain the vehicle.
Well,
So-
what do you think when they want to inspect it? They had to send a separate letter and say, we'd like to inspect it. So by the way, that means don't get rid of it?
I understand your point, and I'm not trying to be silly and saying that there was a need for something additional to be sent. with
Okay,
the
well, that's
request.
how I interpreted what you just said. I mean,
Okay.
you get it,
I-
you get the notice saying we want to inspect this. So when you have a duty to your client, so now your client says, well, I gotta sell everything before, okay, I get it. He wants to sell it, but he can wait to sell that until it plays out with the trial court as to what's going to happen regarding the inspection.
Let me ask, let me follow up on that question too, because it troubles me. And I'll ask you a blunt question. Did you notify your client when you received the request to inspect the car from opposing counsel? And if not, why not?
And respectfully, I don't know that that information is found in the record. And
Well, you just
so-
talked about something that was outside the record that benefited you.
So how so?
You just mentioned it wasn't part of the record that you filed a response, but you filed a response.
I was trying to answer a question,
I
but
understand.
I don't see that that was part of the appellate record, which is why I'm not stating with certainty the date and the substance of that response. My recollection, which you're asking me to answer, was that I did not know of the vehicle having been disposed of.
I'm just
until we-
asking you if you notified your client after the request to respect had been received. Inspection had been received.
I don't want to assert personal knowledge of something that I can't assure you one way or the other. I candidly, I want to be candid to your honor, but I also don't want to state something, especially when it relates to communications with my client, that I can't tell you with certainty what I did or didn't do. I think it's an appropriate question, and I apologize, I'm not giving you the answer. I think, and again, the record will correct me if I'm wrong, although unfortunately I don't see this part of the appellate record, that there was a response, and the response was, I was unaware of the sale of the vehicle. By the way, let's be clear, they didn't say a date and time that they're going to inspect the vehicle. It was a nebulous, we're going to inspect the vehicle within 30 days. There was never any coordination of a date and time. Council never reached out and said, hey, we would like to inspect the vehicle. Can you give us this date and time to inspect it? We have XYZ experts that are going to come inspect it. And I suspect the reason.
Why do you think they were sending the inspection notice?
There's some reverberation going on here. Because they had a desire to inspect it at the last minute, which is what.
Well, I mean, it wasn't, certainly they're going to use it to have an expert inspect the thing. They weren't just saying, we want to send the janitor to come and look at the thing.
I hope that it wasn't perceived as being silly. Obviously, it's not going to be a janitor, but let's be clear. The expert disclosure didn't talk about any electronic data recording, which is what they call black box data. They didn't talk about what the inspection was designed for, the purpose for. For all I know, it was to look to see what repairs had been done to the.
Well, I mean, you indicated that you believe that their disclosure, their expert witness disclosure was untimely. It really wasn't untimely.
I disagree. Now, I don't want to quibble, but it was untimely.
Well, when was it
says
due? November 25?
It was due no later than 60 days before. I understand.
Okay,
that
so
there
you had 60 days. They could have filed it on the 60th day, right? Before. No later than 60 days,
no
right?
later than. yes.
Okay, then the 60th day was a holiday, right?
I understand that that's how they define the issue.
Well, that is I mean, you're saying you don't want to sound silly, but I mean, that is it. If the day is a holiday when they could file it, and don't they then, under our rules of procedure, get to the first business day?
I suppose that could be an interpretation.
How is that not the interpretation?
I interpret no later to mean you don't have 58 or 59. No later means you could do it 61, 65, 70 days before the deadline, but no later than 60 days. That's just how I analyze that issue, Jeff. But again, I didn't even make that germane to the plaintiff's argument on the issue that it was untimely because it was 2 days or 3 days late. That wasn't the germane issue for Judge Beamer's analysis. So Judge Beamer, I think very carefully, in fact, she began her ruling by saying, I have conducted a Binger analysis in deciding these issues. They say in their brief that she made these rulings without conducting a Binger analysis. The very first sentence out of her mouth when she ruled was, I have analyzed this issue under the Binger analysis. Was there another question before I get into my notes? All right, so the bottom line is that from the plaintiff's perspective is the appellant has a heavy burden to show that Judge Beamer has abused her discretion. Abuse of discretion is a heavy burden, a heavy standard for the appellant to show. And in this instance, the judge was so articulate as to not one reason, but the multiple reasons. She articulated the reasons why she perceived there to be prejudice. She explained that it exceeded by 1 full year the Florida Supreme Court's mandate that cases be tried to resolution within 18 months. And so
Let me ask you this, putting aside the policy considerations coming from the Florida Supreme Court as far as timeliness, and putting aside the plaintiff's desire to move. I mean, one way to look at this is the plaintiff filed a lawsuit in Orange County and is responsible to stay there until the lawsuit is finished. What was the prejudice, in fact, to the plaintiff from the expert disclosure? I mean, I'm with Judge Lambert. I don't think it was late. So what is the prejudice, in fact, to the plaintiff, putting aside policy considerations of timeliness and the desire to leave the country?
I'm not sure I'm following the question, so forgive me.
Well, the first Binger says, we look at prejudice, and what we mean is prejudice, in fact, not the fact that the opinions will be adverse to the plaintiff, but what is the prejudice resulting to the plaintiff from allowing these witnesses to testify?
Well, let's be clear, there was prejudice. Number one, even that which they disclosed is not the topics upon which they said that they would express opinions on. So I would define that as clear prejudice that you didn't, and therein lies the difficulty and the problem. These experts, it was shown by me, had not even been provided the first piece of paper by the time that their supposed opinions were being disclosed.
I recognize that. The disclosure kind of covers the waterfront. These are all the things that my expert might testify about. And what you ended up with was a report that was some very, small subset of those things. But what, from a timing standpoint, what was the prejudice to the plaintiffs? I mean, why couldn't the plaintiffs have, for example, the plaintiffs didn't depose Dr. Livingston, the radiologist, before, why couldn't the plaintiffs have proceeded to trial and cross-examine these defense experts just like they did with the other experts?
I think that's a good question, and let me see if I can address it. And I think that the topic was broached previously. I disagree with the notion that there couldn't have been a Daubert motion filed with respect to an accident reconstructionist, and then this other person who's not even truly an expert, but his opinion was going to be, because there is no event data recording, that means that the impact was so minor that therefore it could not have been recorded. There's no way. First off, that was never disclosed as an opinion. I don't even believe it's a subset of the opinions generally disclosed by this gentleman. So to answer your question, the prejudice is you're punishing the plaintiff who didn't do anything with respect to these issues. I know they're going to say, well, he sold the vehicle. Again, Judge Beamer said, this is an auto accident case. If you needed to see the auto, you shouldn't have waited until the end of November.
If the car had been sold before any discovery request was sent for the car, I think we wouldn't even be talking about it. But it was sold after the request was made. And I also want to point out in the expert disclosure, it says for Kelly and for Wilcox, the rate of speed the vehicles were traveling, and they both refer to the fact they want to examine the accident vehicle. So they wanted to examine the accident vehicles, which they did, and they wanted to, testify, at least Wilcox did, about the speed. His ultimate opinion was 3.5 miles an hour. So they were there. Granted, there was a whole lot more in that disclosure, and it was couched in terms of may include, but not limited to. So there's a question of the specificity under the pretrial order. But was there any surprise here? What was the plaintiff's inability to deal with this evidence? I mean, this is an accident case. Accident reconstruction experts get called. What's the prejudice?
Again, the prejudice is they didn't do a proper disclosure. They didn't even answer interrogatory 6 that acts specifically for the summary and the basis of the opinions held by the experts. The plaintiff had to file a motion to demand compliance with the uniform trial order with respect to the expert disclosure and with respect to answering this expert discovery, specifically interrogatory 6. They don't even offer their opinions as to what they were going to say until well after the discovery deadline has expired. In a setting where for 2 years, nothing was done by the defense.
I think the question though was, what's the prejudice?
The prejudice is you're literally giving that information to the plaintiff at the very last minute in a setting where you never disclosed that that's what those opinions would be. And the reason they didn't disclose it is they had never even conferred with these experts to obtain what the basis or their preliminary opinions would be. If everything was going to be contingent upon an inspection of a vehicle, then why was that vehicle inspection request not done until the very 11th hour in a case where you had 2 years of litigation time?
It was not an untimely request. It made it, yeah, in hindsight, we could all try cases better, prepare cases better. It wasn't an untimely request for them to have it, and they needed to have the vehicle to provide their opinion. If your client had not disposed of the vehicle and you would have responded, I mean, they could have gotten it done. And the depositions could have been taken before the pretrial conference, and then both sides would be able to prepare and present the best evidence that they want to present. The jury would be fully advised. That seems to me what the case is about here. And obviously my view of things might differ from yours, but
Yes, sir, I understand. And I guess really the salient point is whether Judge Beamer's analysis, whether she abused her discretion as to how she analyzed, it's her trial order that wasn't complied with. It's her discovery deadlines that were looming and pending. It's her visit.
that's not overarching. That doesn't, well, the trial judge says this, so we can't look at it. I mean, there wasn't an evidentiary. Was there an evidentiary issue that she weighed evidence on it? She heard argument and made calls. We hear arguments and made calls. I mean, is it not a de novo review we have?
I don't believe abuse of discretion by definition is de novo, but to answer your
But I mean,
point,
she's not hearing evidence and weighing testimony. She's hearing the argument. She's looking at her court file as we can look at her court file. And has these arguments that we can see in the record. And so we decide whether she should have done this or not done this under, I guess, you said the abuse of discretion standard. But that's not, you know, that's not sacrosanct. People, we read opinions every week about trial judges being reversed for abuse of discretion.
I do believe that there was in the nature, I'm not going to say an evidentiary hearing, so forgive me if you think I'm quibbling, but there was in the nature of her assessment and analysis of the evidence.
She's listening to the argument, just like we are listening to argument. And she's saying, well, this is my order says this is the timing of events. She didn't take testimony about it in a way saying, well, I don't believe that witness, did she?
I do believe that she was submitted their reports, and in addition to hearing the argument, had the benefit of those reports. And at trial, I know that there was also a proffer made to her that related to the substance of the reports. So again, I'm not quibbling with your honor. I know you asked me was there an evidentiary hearing, and the implication was she considered no evidence. I do believe that she
Well,
considered
it was
evidence.
proffered because it was excluded, because if they didn't proffer, then you'd be saying to us, well, you didn't preserve it by not proffering it, so no harm, no foul.
And that was the second time. The first time I do believe the evidence was presented to her was at the hearing that was held pre-trial. I do believe that substance was presented. Judge Shraver, you also asked a point that I do believe the record would show that Judge Beamer addressed, which is there any such thing as a short continuance in the Ninth Judicial Circuit? And I do have a recollection that Judge Beamer addressed that when the request for the hearing, request for the continuance was made at the last minute. And akin to, as what you said, address the fact that there is no such thing as a short continuance in the Ninth Judicial Circuit. I do believe that it was a hearing transcript that was filed. I do believe that so.
So you're saying here in the record that in Orange County, if you have a trial, forget about the facts of your case. So you're on the Monday morning of trial and it finds out one of the material witnesses or the experts is very ill and the case needs to be continued, that the trial judge will say, well, that's a very valid reason to continue the case because your experts in the hospital will see in 2026. That's the policy. That's the administrative order here in the Ninth Circuit.
No, sir.
Okay, so that trial judge in my scenario, I know, don't tell me that's not the facts of the case. I know trial judges get to, or appellate judges get to make hypotheticals. So under that scenario, the trial judge certainly would be within his or her right to say, okay, I'm sorry, I hope your expert or your witness finds good health. We'll see you next month and we'll try this again because both sides should, that's just completely barred here in the Ninth Circuit?
I did not say that.
Well, I'm not saying you did or didn't. I'm asking the question. I mean, there seems to be this underlying thing. If a continuance is granted in this case, you wouldn't be seen for another 24 months based on something is in the air in the record here at the Ninth Circuit. Is there something that says that?
I don't believe she said 24 months.
Oh,
but I do
okay,
believe-
all right. Don't quibble using your term today. Don't quibble. I'm, 18 months, 19 months, 7, why couldn't she just continue it in a month? That's not precluded, is it here?
I don't believe that that was an option that was available to her, given that she had expressed her docket.
It's her docket.
I-
So
I
she as a
understand that.
trial judge should say, well, I've got 10 cases or 20 cases next month, but because of the unique circumstances here, or whatever, I can't put you first on the next month? Is there a chief judge administrative order in this record that says that?
No, sir.
Okay, is there anything that says that?
I believe she said something.
She said that I can't put you on the docket because,
No, she said that there is no such thing as a short continuance in Orange County, and I see I've only got 30 seconds left. So if I could just wrap up to say, the real issue is here is whether Judge Beamer, who is an experienced civil trial judge, whether she abused her discretion by enforcing her own uniform trial order and by following Florida Supreme Court mandates to get cases resolved within 18 months in a setting where it was already a year late. And she had expressed and acknowledged it, and also in a setting where it's very clear in the record that the defense did nothing essentially until the 11th hour for 2 years. They can say, well, it was a predecessor's fault, but I know no case law that says you can avoid the consequences of failing to adhere to orders by blaming your predecessor. The defendants, they say, well, you don't punish the parties for the sins of the lawyer. They have a claim against the lawyer if what that lawyer did was so bad. But the judge was very clear that she has orders that she has to enforce, that she's following the directives. I'm
That's right.
sorry, I've exceeded my time. Thank you for your time and attention.
The trial judge did say, I'm required to follow Binger, and she did outline the factors. And then she went on to not follow Binger.
Can I ask you this though? And it kind of just stems from the dialogue that my colleagues had with your colleague. Does Binger apply here? Was it a late disclosure? Does Binger apply? Was it a late disclosure?
Binger does apply because it was it was a non-compliance with a court order. So, yeah, and that resulted in striking a critical witness.
but I thought you did comply with it. It's timely. It was filed on the first day. I disagree with Mr. Byrd here. It's the 60th day was the day after Thanksgiving. So we then go to the first business day, which is when it was filed. So it was a timely disclosure and it complied with the order about here's the name and address of the witnesses, here's what their general testimony is going to be. The order did not require an expert witness report to have been filed. Am I correct?
That's exactly right. And actually the trial court, in making her ruling, she said you didn't provide an ultimate opinion. And that's not what the trial order required. When I say non-compliance,
I just have to ask it again though, because if Binger doesn't apply because it was a timely disclosure, then is it a completely different scenario that we're talking?
no, because it was,
Isn't your argument better is what I'm trying
There-
to get you to agree to?
well,
Binger doesn't
okay.
apply.
Okay,
Is your
yes.
argument better?
No, I mean, I don't, well, what is the consideration when the trial judge strikes a critical witness based on an alleged non-compliance? And in this case, when I say non-compliance, it's the failure to, what the trial court found, the failure to provide the 3 depot dates.
What Chief Judge Travers, if you're timely complying with the pretrial order and a judge then strikes your witnesses anyways, that's really bad compared to you didn't timely comply and then Binger gets involved in saying, well, is the death penalty civil death penalty by striking all the witnesses, is that the proper sanction or remedy or whatever term we want to use today?
I agree. Okay, I understand what you're asking.
That's what he was asking.
What you're asking.
Okay, so do you
so-
agree that that's what happened?
So I agree that it was a timely disclosure
Okay,
of the
then I'll stop
experts.
you there. If it's a timely disclosure, does Binger apply?
If it's a timely disclosure of the expert, but it's alleged that they no, I agree. I understand what you're
Then my
saying. I'm just talking
And the
about
problem is a separate problem, which is that you haven't briefed that argument.
well, then we move to the argument that under the circumstances, we would have been entitled to some sort of consideration in the form of a continuance. The trial court did not undertake any analysis as far as was the party moving for continuance, would we have been prejudiced by the denial? And as a matter of fact, Judge Beamer actually said, defense, I understand you're going to be prejudiced, but the plaintiff's going to be prejudiced because he's trying to move out of the country. And the only thing holding him up is this trial.
Counsel, we have another for the question of whether a continuance should have been granted. Again, we have this other balancing test, and the trial judge invoked, the three factors, one of which is the, dilatory practices or foreseeability of the time crunch. The judge specifically referred to dilatory practices, not in the sense of, intentional delay, but just the fact that nothing was done. And wasn't it foreseeable on, again, if we assume, time began when the final trial counsel took over, wasn't it foreseeable on August 22nd of 2022 with the trial order in place that, X, Y, and Z must be done before the pretrial conference? That wasn't unforeseeable, was it?
No, it wasn't unforeseeable that those things needed to be done. Was it unforeseeable that when we did a request to produce the vehicle and we said we want to inspect it, that the plaintiff would have sold his vehicle? Was it unforeseeable that plaintiff's counsel, we couldn't get hearing dates, we couldn't get we tried to get depositions to cooperate, to schedule the depositions. We had the plaintiffs out of the country, the plaintiff's
But
counsel
counsel,
has eight
wasn't it-
trials.
Wasn't it foreseeable, at least foreseeable, that not getting depositions lined up or not getting your experts and their opinions lined up by the disclosure date, which let's say it was November 28th, wasn't it foreseeable that if you didn't have anything scheduled or even any opinions in the hands of your experts by then, that you would run out of time to get all that done before the pretrial conference?
Well, I mean, plaintiff's trial counsel had attempted to comply, was doing everything he could to comply so that, to stay on track. I guess he ran into issues with the CME physician, and in the record, he moved 4 times at every stage. He said, Judge, I'm trying to comply, but this is the roadblock I've run into now, and this is what I'm coming. So he did, and the trial order does say for good cause.
Let me
So,
ask this. Let's say the vehicle was not sold. So your colleague over there files the request to produce or request to inspect. Mr. Burr's side has 30 days to respond. There's nothing absent some court order requiring him to do it quicker, which I don't know, there was a request for that to happen. He could have waited till day 30, and if it was a weekend or holiday, he could wait till the following, play both sides here. He could have filed a notice saying, I have no objection to you inspecting it. And sort of, I think, following what Judge Ganem is saying, is that at some point, all right, so mid to late December, right around the holidays, you get things, go ahead and inspect. You're into January to inspect. You're getting the report later after that. You're past the time frame to take depositions, or you're pushing right up to it. At some point, and I get it that your colleague over there parachuted in to take over for a law firm that had apparently not done much the first 20 months of their representation. But there was a period of time of inaction of record here that pushed everything back further and further. And in Judge Beamer's defense, they are getting direction from the Supreme Court saying, you need to move these things. You need to move it. And so she's trying to do that. And so where do we give relief under those circumstances to say that Judge Beamer reversibly erred in her calls?
I think you give relief based on the judge's own comments throughout the record. I mean, it's not a case of intentional non-compliance or dragging this matter out. She recognized that counsel had done everything in his power to move this case along. I don't know that it was foreseeable, to answer your question, Judge Gann, that from in August, but certainly as it moved along through the summary judgment proceedings, through, the discovery issues, the CME, I think as we got further along, to go backwards and Monday morning quarterback, it wasn't foreseeable that all of these things would happen that would delay. And if the car had not been sold, I can't say, how fast the expert would have come in and done the inspection, but we certainly would have tried our best to get that done under the circumstances. And I understand as I've said before, the Supreme Court mandate, and that was a big issue, a big basis for the trial court ruling as she did, but the client with a $3 million verdict and no ability for the defense to come in and present any causation evidence, that's prejudice. And then let me just emphasize again, right out of the gate, plaintiff's counsel comes in an opening statement and says,
Do we have any other questions on the panel? You're way over time, but you were answering my colleague's question, so I'm not going to let you go into a new point.
okay,
Thank you.
thank you. Thank you.
We'll be in recess.